Thanks for saying this is Daybreak, and the hashtag on X is Citizen Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. On my immediate right, Dr. Amos Omolo, advocate of the High Court and expert in digital policy and transformation. Good morning, Dr.
Good morning.
Appreciate it, and thanks for making time.
Thank you very much.
Ahmed Ashish, governance commentator, also joins us this morning. Ahmed,
Thank you for welcoming me back. Ayub.
Professor Peter Kagwanja is the Chief Executive Officer of Africa Policy Institute. Prof, good morning. Jared Mugende is an advocate of the High Court, will be joining us shortly. Sheila Olang, who is development economist. And thank you so much for your time. Appreciated, gentlemen. Let's begin with a look at what's causing decry in the country. And this is in relation to the bills that the head of state signed and are now acts of parliament. And the front page of the Standard has that breakdown of the Cybercrimes Act and the implications therein on the 5 itemized issues that they have managed to flesh out from the Act of Parliament. Now, first, coming to Daktari, and we'll get to the specifics later. Yesterday, we had seen the former Chief Justice David Kenani Maraga. Seems this is now coming out to cause even more public outcry about the timings and also the contents of the Act.
Yes, thank you, Ayub. I think it's important to understand the context and background of this particular amendment and new legislation. Now, one of the international instruments which Kenya is about to ratify is the Budapest Convention. And this convention provides an international framework for dealing with issues to do with cybercrime and cybersecurity issues. So probably what the government was trying to do in this particular legislation is to align it with the Budapest Convention in terms of definitions, broader definitions of different kinds of crimes that may be envisaged under the law. So I think this is the context from which this legislation has come into place, but we'll be able to look at the other aspects that are of the country, including what the former Chief Justice Maraga was alluding to yesterday. Yes.
Okay. Yes, Ahmed, your first thoughts on the response by the former Chief Justice, who had said this remains an affront on the legacy of the former Prime Minister Raila Odinga, and says, see you in court.
You know, if I can remember, there's a writer from South America, I think it's called Garcia Marquez. He wrote a book called 1,000 Years of Solitude. And he said fiction was invented the day that Jonah, you remember in the Bible, in the Quran, we have the story of Jonah, who was taken in by the whale. Yeah. But what did Jonah say to his wife when he came home? You were just talking about my marital status, which is, why are you single? So when Jonah, the Prophet ﷺ, walks into his wife's house and says, I was swallowed by a whale for 3 days. And it is the Creator who made all this for me to return. I think that fiction was invented because I'm sure his wife would never accept this explanation. So I think that the fiction of signing bills in State House has actually morphed into something called a legal fiat. And my learned friend on the left will explain that in a minute. That this legal fiat is, first of all, the president said that that we should all stop what we're doing and mourn probably the greatest political leader of our generation. And exactly a few hours later, he assembled all his state officers and under the cover of darkness signed perhaps the most draconian bills that this country has ever seen. And I was just speaking to my friend, my longtime friend, who is a very senior lawyer and well learned about these issues. About it, I think that Mr. Ruto, the president, is courting absolute trouble. We are already in even deeper trouble politically after the exit of the former Prime Minister. I think that this country needs to go to the benches. We need to reject these laws because the last law that he signed nearly brought a revolution. This was the tax bill. Now these are ones to curb our freedoms under the pretense of pornography, terrorism, and you know, they can use anything with terrorism. With a bill that says that terrorism is so and so, it's very easy for your civil and political rights to be infringed upon. And I think that the legal community now has a special responsibility to educate and debate these bills, because we have seen that the Parliament has done another flip-flop by the entire parliament. This parliament is going to join the government in toto because none of them are going to return. So they're going to try and make returns in the next 2 years through corruption, and they're going to pass these egregious bills, and we ought not to accept it at all.
Okay, Council, do you share statements by your colleagues in the profession that the Cyber Computer Misuse and Cybercrimes Act threatens freedom of expression?
First of all, good morning.
Good morning to you too, and welcome.
To meet you for the first time.
Pleasure. Welcome.
I think I'm the youngest face.
Yes, please.
But certainly not young at
We can
mind.
tell.
Perhaps I can begin just briefly in 30 seconds by explaining that in 2024, there was a famous movie generated by Jason called The Beehive that was expressing exactly what is at contention here today, particularly involving fishing, where Jason Statham, his friend was murdered, and he went on a revenge mission and found out a very big racketeering ring and organized cybercrime ring that was stealing and ripping off millions of shillings. I am not certain that I fully associate myself with the sentiments that Article 33 is under attack, because every bill in itself has something called the statement and memorandum and objects. And those memorandum and objects supersede any oral conversation we can have, because the best evidence is what is in writing. And it is in recognition that technology will always supersede law 10 out of 10 at any particular point. Third point is that the state, ordinarily, we expect that injuries to the person are easily recognizable. If I poke my senior Kagwanja, I have harmed him, therefore a case of assault, murder, you know, crimes that we can easily see with our own eyes. But the crimes that are not easily recognizable by eyes and are only felt in terms of effect, or the injury is in the psyche, have become more complex and have necessitated the law to try and catch up. And I'm using the word catch up because that is exactly what we are doing in any case concerning cybercrime law. So the arguments of Article 33, according to my mind, may not necessarily apply in terms of this particular conversation, considering we still have checks and balances. With every single case has to be brought into court, there is a director of public prosecution who has to approve that charge. Constitutionally speaking. I'm not talking about what we foresee. And because that is a conversation where I'm seeing that heading, that direction, everybody is foreseeing and portending danger. I am talking about what the law says. If you apply the law the wrong way, you will definitely be held accountable, whether you're using that purpose or wrong. So what is in law is prevention of organized cyber crime.
Prof,
let me say this. You know, we have to be vigilant about our democracy. And I think this debate is healthy for me, for you, and for President William Ruto. It's very healthy for all of us, because we are all minders of our democracy. So that is very clear. I was in Beijing about a month ago, and I was taken to a tour of the new frontiers of technology, basically the AI, robots, and so on. And I as we're walking through, two things happened. They said, why is this not operational? They have done rings around the city of Beijing, inner ring, all the rings and then they are talking about these are spaces of law, because you cannot operate on technology until there is a law to govern it. We are going to go through this, not necessarily because we are restricting the space of democracy, but because technology needs to be governed by law. Otherwise, we'll have a whole wilderness, Wild West. That said, I am not one of those who are very worried about our democracy. I'm not. Why am I not? Because not Hashi, not William Ruto can reduce the space. Because it is us who created the space, us to protect it. The story is told now that he has passed on, we must say this. When you can check the veracity of it, but the truth of the matter is that when Raila Odinga took the Ministry of Transport, Roads and so on, under Mwai Kibaki, he demolished his brother's house, which happened to have been in one of those areas which are identified as. So even if you do things today to protect yourself, they are immutable. They are not permanent, because our law will always side with the people. Finally, it is important to recognize that there is no law that governs. It's individuals who govern. President Mwai Kibaki is reputed to have been one of those who opened democratic space, including speeches, and he himself would say things, and the public would also say things, and the space opened up. He governed under the same law that President Moi governed. The same law President Kenyatta governed. What was the difference? It is the disposition of the individual that made the difference. And therefore, it's for us to change our culture and be vigilant about protecting our democracy rather than... So within that framework, we'll have to examine all these laws. Any of them that does not add up, it is only there for a while, not permanently. Otherwise, it will be challenged, either in our courts or in our public space. And if it is too much, then you find us going to the streets. Now it's the Gen Zs who are going. If it is too much, we'll become... Raila is...
I was there last time.
Raila was...
Shocked Ayubu thought that I was mad.
Raila was doing it for us. Now we have to do it for ourselves.
Okay.
So don't get surprised if you get too many Railas into the street.
Yeah. So
we are conscious.
Okay. Dr. I'll come to the specifics, but allow me to also introduce Sheila Olang, who joins us. Sheila, good morning.
Morning, Ayub. How are you?
Pleasure having you here.
Thank you for having me.
Asante.
Yeah.
Your first comments on the bills, the acts of Parliament now. I mean, two that stand out, the Cybercrimes Act, and the specifics we'll be getting into. As a young person who has been on the streets demanding for freedom of expression in the year 2024, what are your quick thoughts on this?
I think it's quite...
Thank you.
What is clear is that we needed something to be done. First of all, if you look at the bill as a whole, there are some good aspects of it, right? So you have issues of phishing, you have issues of trying to prevent, because you have a lot of our parents who actually fall victim to crimes of, people, so you're getting called, you give your personal data, I'm calling you from Safaricom, give me your PIN number, and, there's some good aspects of it that is going on. I think for me, why I would call it punitive is there's certain aspects that were pushed in that are very vague. I'm worried about definitions. You have terms such as annoyance, which I think is very subjective. What annoys you versus what annoys me is very different. Maybe my threshold is higher, maybe it's lower. So first, I have an issue with the definitions. I think the definitions need to be clear. They need to be anchored within the Constitution. The Constitution will always be supreme to anything else. So that's the first aspect of it. The second aspect of it is that it focuses more on punishment and less on readiness.
Yes.
right? So you have to first invest a lot in making sure that you have a good foundation for compliance for everybody involved. So everybody must be informed, what is this, including businesses, including companies, so that they have the right capacity in order to be compliant. But it's really punishment focused, which makes me suspect that it might be used, or it's about to get used for all the wrong reasons.
Correct.
And what do I mean by this? I mean by the fact that, have you done enough public sensitization to explain to them that, you know what, Ayub, when you go on Facebook and you do this on that, because I think it is relying a lot on morality, but morality for us is very subjective.
Correct.
We saw like what has happened yesterday with the governor of Nyeri coming out and speaking ill about Raila Odinga.
Very
in my
bad.
culture, I'm Luo. I'm from Migori. We do not speak ill about people we have lost, period. He could have been
don't
anything.
Speak ill of dead people.
I mean, you could have been anything. But once you rest, and we respect you because you rest, right?
Very
and
bad.
so, exactly. And so it's not to say that there is lack of legislation. I think it should just not be opportunistic. And then to pass this on the morning when we lost Baba is also quite telling. We were all up in our emotions, and we did not have time to go through it. So I think we need to really go back to the drawing board. We do need legislation, however. I see that it's trying to work on cases of suicide and things like that. Have we invested on mental health? Because sometimes you can't control what somebody will say, but you can control how you react to what somebody will say. Have we invested enough in mental health? Have we, so there's a lot that needs to be done, but it should not be opportunistic in a country where we have a lot of public mistrust. I do not trust the government to be able to enforce this in a fair and rational way.
Daktari,
yes.
Let me flesh out three things here. The criminalization of publishing false information, which is digital information, carries up to 3 years imprisonment or 5 million Kenyan shillings fine. Vague definition of cyber harassment targets activists and opposition figures, handing them a jail time of 5 years or 10 million Kenyan shillings. Allows police to demand user data from service providers, raising concerns over political spying and privacy violations. State agencies can block websites or online content without court approval, enabling shutdown of critical media and the voices of dissent. There is vagueness around the wording and possible retroactive enforcement of the law, which creates fear, leading to censorship and self-censorship online. This is the question then, Daktari, as the expert in the field. Where do we draw the line between freedom of speech and what is morally right and what is legally right?
Thank you. Now, I started with alluding to the Budapest Convention because I knew that this was going to arise in this discussion. And first of all, I think in terms of the reading of Article 33, I agree with my learned friend here that there are certain limitations that are imposed by the law in terms of freedom of speech, whether it is in contents or verbal. So there is a thin line in human rights and other rights of different categories of individuals, whether business in society. So globally speaking, and if you look at the United States, for example, under their law, they have also allowed, for instance, general surveillance by security organizations like the FBI. So in terms of general surveillance, in many jurisdictions, including the US, this is allowed. But when it comes to very specific actions like maybe confiscating equipment, then a court order is required. So some kind of judicial oversight is required in very extreme cases. But it's not Kenya alone that has enacted this kind of laws. For example, South Africa has similar laws, Nigeria, Ghana, Uganda, and Tanzania. So if you look at the overall aim of this legislation is to protect people from issues to do with pornography, terrorism, and related issues. But if there is danger of violating human rights, then this is where the judicial oversight comes in, and the court has got some oversight role in terms of to what extent the state can go in terms of applying this kind of legislation. So I think I agree with Professor Kagwanja that I don't think it is as bad as we think. I think Kenya is on the right track generally in terms of human rights. And this particular legislation also says that it will not delimit the Bill of Rights. So to me, I'm not very alarmed by this legislation per se, but we just need to balance various interests.
Yeah. You can, my learned friend on the left, who is a very long-time friend of mine,
yes,
speaking like he's in the broad-based government. I think that we ought to call him out. The great Justice Brandeis, probably one of the leading scholars on speech, said that we want more speech, not enforced silence. And we ought to reject enforced silence, which I think is a creeping sentiment in the legislation that we have. Now, to craft a law, and the way that the lawyers at State House crafted this law, it is very, 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 very...
It's a bit... Wajir East MP.
Probably the most conservative member of parliament in Kenya. All his legislation, I think this is the first time he stood up on the floor and brought a legislation, and then it became a very right-wing agenda. He's my really good friend, and I hope he's watching. I think that the president is using his political allies to write down certain laws in anticipation of the coming elections. Now, what the lawyers are telling us, that the law has been crafted in a certain way, and that we should not malign it with any kind of political overtones. But of course, as politicians, and as politicians, one of the most important things that we look at is the consequences of the law. And what is one consequence of the law? It's this enforced silence. Because Justice Brandeis has written about it, and I've read that piece on enforced silence. And I think that if we have sent a chill into the society about what we're going to say. For an example, I just spoke about Jonah, the prophet Jonah and the whale. That's, that could be misinterpreted as false information to the public. And I could be charged with it. And I'd have to go to court over it. That means that they use the court system like the days of Charles Njonjo. Remember, we had a constitution in this country. Remember that? And what was the constitution? What was the constitution then? They went to the High Court every day with probably some of the best lawyers in this country to maintain the legal fiat in this dictatorship. And I think that we cannot trust the president with more speech. We can't trust him with it because he did not vote for this constitution. That's on the record. He went to the ballot and he said no. So he is not a guardian of this constitution. He doesn't respect it. He doesn't want it. And can you imagine if we did not have the constitution of 2010? Those tall fellows from Rift Valley would be inside this studio right now. So I put it to you that apart from my lawyers here on the left, on the right, we ought to be able to not accept that the wishy-washy legal language that may entrap us into cutting and curtailing our freedom of speech. That's my worry.
Yeah, Council, I'll come to you and Prof. After the break, brief commercial break here on the broadcast. The hashtag on X is Citizen Day Break. The SMS code is 22422 at Citizen TV Kenya and Ayub Abdikadir. And we have more time to explore this matter here on the broadcast with the lady.